Welcome to the Courtroom Chronicles. This channel is dedicated to educational content based on real-life cases and true events. This content shared here is drawn directly from the actual case file, and no names, places, or items have been changed. However, the content has been carefully summarized and presented for educational purposes in a comprehension format to inform, enlighten, and spark meaningful discussions. Whether you're here to learn, reflect, or simply understand the real-world scenarios better, you're in the right place. We believe in the power of truthful storytelling to educate and inspire. Disclaimer: while all stories are based on real cases, they are presented in a condensed and structured format for clarity and learning. Viewer discretion is advised where necessary. This case is cited from the Nigerian High Court online file, which is public record. This is a case between Stanbic IBTC Bank Plc v. Pinnacle International Academy Ltd. and others. Court, High Court of the Federal Capital Territory, Abuja. Presiding Judge, Honor Justice Sylvana C. Origi. Date of judgment, 24th of February 2021. Facts of the case. Stanbic IBTC Bank Plc, claimant, sued Pinnacle International Academy Ltd, first defendant, and its directors. Mr. Asabor Victor, second defendant, and Mrs. Asabor Martha Ehinoman, third defendant, claiming $16,079,222 as outstanding loan debt as of 31st of March 2016 and 36% annual interest until full repayment. On the 19th of July 2013, the first defendant secured a term loan of $14.6 million for school-related purchases. The loan was later restructured in 2014 to $12.9 million. Despite repeated demand notices, including a final demand in November 2015, the defendants failed to repay, prompting litigation. Legal issues raised and determined: admissibility of plaintiff's evidence, hearsay objection. The defense argued that PW1 bank staff gave hearsay evidence since he was not involved in the original transaction. The court disagreed, relying on Sala v. Bank of the North Ltd. and Kate Enterprises Ltd v. Daewoo Nig Ltd, holding that any company officer can competently testify based on corporate records. Non-joinder of the insurance company. The defendants argued the insurance provider, named in the loan agreement, should be a co-defendant. The court ruled that there was no privity of contract between the plaintiff and the insurance company, and no evidence that the insured assets triggered a claim. Entitlement to reliefs. The court held that the plaintiff proved the existence of a loan, default in repayment, and outstanding balances via documentary evidence. Notably, the first defendant's letter, Exhibit G, admitted the debt and merely requested a 5-year moratorium, a key admission used to support judgment. Judgment summary. The court ruled in favor of the claimant. Defendant's debt fixed at $15,201 for 26.85 after deducting $351,000 post-demand payment. Pre-judgment interest at 36% per annum from 30th March 2016 to 24th of February 2021. Post-judgment interest at 10% per annum until full payment. Costs awarded, $100,000 to the claimant. Who won and why? The claimant, Stanbic IBTC Bank Plc, won. Reasons the defendants lost. Admission of debt. The first defendant admitted the debt in writing, Exhibit G, only seeking leniency, not denying liability. Lack of contradictory evidence. Defendants chose not to call witnesses, resting their case on the claimant's evidence. Valid guarantor agreements. The second and third defendants had signed personal guarantees, Exhibits B1 and B2, binding them jointly and severally. Hearsay argument rejected. The court upheld the right of a company representative to testify based on records, even if not personally involved in the transaction. Irrelevant insurance argument. The insurance covered only the pledged assets, not the loan itself, and no claim event occurred. Further analysis and how this could have been avoided. Better risk assessment by borrowers. The defendants should have realistically assessed their financial capacity before taking the loan and should have ensured a repayment plan was in place, especially after the facility was restructured. Transparent communication. Instead of seeking a 5-year moratorium only after default, the first defendant could have negotiated more proactively and documented financial hardship with evidence to support restructuring. Proper record keeping and loan monitoring. defendants could have maintained precise records of all payments and corresponded formally with the bank about difficulties, rather than relying on informal pleas. Enforcement of insurance policy, if applicable. If the defendants believed an insured asset had suffered loss impacting repayment, they should have triggered the insurance claim themselves or formally demanded the insurer's involvement. Defensive litigation strategy, choosing not to testify or rebut specific bank claims, e.g., computation of interest, outstanding principal, was a major flaw. By remaining passive in litigation, the defendants effectively conceded key arguments. Thanks so much for watching, fam. I really appreciate you spending your time with me. If you enjoyed the content, don't forget to hit that subscribe button, drop a comment below, and let me know what you think about the case. I love hearing your thoughts and feedback. And hey, if you felt a connection or learned something new, give this video a like and share it with someone who might enjoy it too. Until next time, stay safe, stay real, and I'll catch you in the next one.